Procedure and Indian Evidence Act. The laws governing the criminal justice system over a century were enacted by the British to penalize a common man for commission of offences and to maintain law and order. The old laws were enacted with a different mindset. It needs little emphasis that laws of procedure need to be flexible enough to evolve according to changing needs of the society. New forms of crimes have emerged over a period of time, such as cybercrime, financial fraud, identity theft, that require a dynamic method of investigation, proof and procedure for trial. Technology is a powerful tool for investigation and collection of evidence. The legal framework therefore has to adapt to incorporate the advancements while safeguarding the privacy rights. Speedy justice is a cornerstone of a fair and functional criminal justice system. The administration of criminal justice system needed an overhaul in view of evolving nature of crime, technological advancements, societal changes, and there was a need to ensure speedy justice. The Parliament therefore responded to the changing societal needs by undertaking a comprehensive review of law governing the administration of criminal justice. The new laws mark significant overhaul of our country's criminal justice system and ensure protection of fundamental rights and foster public trust in the legal system. Bharatiya Nagrik Suraksha Sanhita replaces the Code of Criminal Procedure. The legislation includes several changes designed to expedite criminal justice process and safeguard the rights of individuals. The Act aims to implement a series of measures for streamlining the criminal procedures, reducing duration of trial and establishing mandatory timelines for various procedural steps. The Act mandates forensic investigation of offences punishable with at least 7 years of imprisonment. BNSS also contemplates that if a proclaimed offender has absconded to evade trial and there is no immediate prospect of arresting him, the trial can be concluded and judgment can be pronounced in his absence. The Act also provides for electronic filing of first information reports, service of documents, and even court proceedings in certain cases. The enactment introduces technological compatibility for issuance of service summons by the court through electronic form authenticated by the image of seal of the court or digital signature. Section 202 of the Act expands the scope to include offences committed by electronic means as well, whereas Section 254 provides for use of audio-video electronic means in sessions cases for deposition of evidence or a statement of witnesses, police officers, public servants, or experts. One of the most notable features of new code is strict adherence to the timelines. The investigations are now bound by the timelines, ensuring that the cases do not drag on indefinitely. The provision made in BNSS addresses a chronic issue in our judicial system, that is inordinate delay that is often results in justice being denied. The timeline of 180 days is provided for commitment of a case to the Court of Session, whereas Section 263 of the Act maintains the magistrate to frame a charge within 60 days from the first date of hearing on the charge. Section 265 provides a similar provision for trial of warrant cases. The Act also introduces witness protection scheme. Bharatiya Nyaya Sanhita repeats the Indian Penal Code and makes provisions with regard to inchoate offences. Several new offences like organized crime, terrorist act, petty organized crime, hit and run, mob lynching, hiring child to commit offence, sexual exploitation of women by deceitful means, snatching, abatement outside India, acts emerging the sovereignty, integrity and unity of India, publication of false or fake news have been introduced. The inclusion of new offences reflects the will of the legislature keep up with the ever-evolving criminal landscapes. The new provision cater to the changing needs of the society and provide for a mechanism that underlies the need to curb such acts throughout our country uniformly. BNS also introduces community service as a form of punishment. The fine prescribed by BNS have been enhanced substantially, and almost 33 minimum sentences have been prescribed in respect of certain offences, and more than 15 offences have been introduced which carry imprisonment exceeding 7 years. Bharati Saksha Adhiniyam replaces Indian Evidence Act. The new legislation aims to make the rules governing evidence very comprehensive, logical, and aligned with the contemporary principles of justice. Section 61 and 62 of the Act recognize the digital age and streamline the procedure relating to admissibility of electronic evidence. Section 65 of the Evidence Act 1872 has been simplified, and the same provides for admissibility of electronic or digital record. Section 74 and 75 of the Evidence Act have been brought together in the new Act to cover description of both public and private documents. The scope of Section 81A of the Evidence Act has been expanded in PSA, and the same deals with presumptions as to gazettes in electronic or digital form. The new laws collectively represent a comprehensive transformation of our criminal justice system. These landmark legislations are testament to our commitment to create a legal framework which is fair, efficient, and responsive to the needs of the society. The Parliament, by modernizing the new criminal procedures and updating the penal code as well as rules of evidence, has ensured that speedy justice is made a reality. The effective implementation of law is imperative. The law enforcement agencies, the judiciary, and the legal fraternity, I am sure, have been adequately trained and equipped to operate within the new legal framework. The Telangana High Court has already framed rules in the light of new enactments brought about by BNSS to the existing procedure of criminal laws. The High Court, in coordination with the State Judicial Academy, has already organized several training programs for the judicial officers of the state and other stakeholders such as police, public prosecutors, as well as advocates. We are all ready for the smooth, I am sure that we are all ready for the smooth implementation of laws. Thank you.
Thank you, sir, for enlightening us with your speech today and for sharing your thoughts on the new legal reforms. Now, I take this opportunity to invite Honorable Mr. Justice R. Mahadevan, Acting Chief Justice, High Court of Madras, to share his thoughts with all of us.
Arjun Ram Meghwal, the Honorable Minister of State, Ministry of Law and Justice. Shri L. Murugan, Minister for Information, Broadcasting and Parliamentary Affairs, Government of India. Honorable Mr. Justice Ashish Jitendra Desai, Chief Justice, High Court of Kerala. Honorable Mr. Justice Alok Arade, Chief Justice, High Court of Telangana. My brother judges, Justice G. Jayachandran, Justice C. V. Karthikeyan, Justice N. Satish Kumar, Justice Vel Murugan, and Sister Anita Sumant. Former judges of Madras High Court, Justice Sudhandiram, Justice Raghupati, Justice Velamani. All the judicial officers, Additional Solicitor General Mr. A.R. Sundarasan, Deputy Solicitor Generals Mr. Govindraj and Rajesh Vivekanandan, and Shri Narasimha Sharma, Additional Solicitor General, Telangana High Court, Dr. Raji Menon, Secretary, Department of Legal Affairs, Minister of Law and Justice, senior advocates, law officers of state and central governments, the Dean, VIT School of Law, faculty members, distinguished guests and resource persons. Very good morning to you all. It is my esteemed privilege to be among us this august gathering today. We have among us some of the brightest stars in the galaxy of legal world. The criminal justice system of a country has a direct impact on its sociological growth and progress. And this justice delivery system, in which the body of laws is the first and foremost and also the most significant part, must be updated in tune with the times, according to the needs of the society, the perils faced by the society, the protection needed for the vulnerable sections of society, and for better safety and security of women and children. The three new criminal laws, to take effect from 1st of July 24, introduced significant changes to reflect the evolving legal landscape and discard outdated colonial terminologies and phrases used in the current criminal law of the country. The Bharatiya Nyaya Sanhita 2023, the new Indian Penal Code, is progressive in outlook, tailored to the Indian needs and reformatory in approach. This can be seen from the language employed in the Act, the new offences added, the new reformative punishments added, and which are free from colonial clutches. For the first time, community service has been introduced as one of the punishments in Section 4 of the Bharatiya Nyaya Sanhita 2023. It has been specifically provided for 6 petty offences also. Similarly, the Bharatiya Nagari Suraksha Sanhita 2023, the new criminal procedure code has accepted and embraced the new developments and advancements in technology in the digital era. The concept of implementations of zero FIRs, timeline for investigation, admissibility of electronic evidence, mandatory videography of search and seizure, broadening of the parameters of property seizure, mandatory forensic investigation for offences carrying a minimum sentence of 7 years in prison, or certainly steps on the progressive path of the criminal justice system. In Section 479, provisions for bail to under trials prisoners has been relaxed and liberalized. A sympathetic view has been taken towards first-time offenders who are now eligible to be released on bond by the court if they have undergone detention for the period extending up to 1/3 of the maximum period of imprisonment specified for that offence. Also, the provisions prescribing a timeline of 30 days before the governor and 60 days before the president for disposal of mercy petitions, and information to the convict about the confirmation of the death sentence, dismissal of their appeal or review of special appeal, are all commendable measures that strengthen the human rights jurisprudence of India. The Bharatiya Sakshya Adhiniyam 2023, the new Evidence Act, has again been revolutionized by emphasizing on the recognition of electronic evidence as primary evidence. Electronic or digital records, emails, server logs documents on computers, laptops, smartphones, messages, websites, cloud voicemail, and locational evidences stored on digital device have all been included in the definition of documents. Having said this on these new revolutionary laws that form the bedrock of our criminal justice system, a program such as this, where there is going to be an intellectual exchange of ideas on a ground scale by some of the best legal minds, which hands-on experience, that is judges, advocates, teaching faculty, and resource persons, will be thoroughly enriching and will certainly add to the body of available research on the subject. The panelists in all the 3 sessions are persons with expertise in the subject, having both in-depth theoretical knowledge as well as practical experience in criminal law. I hereby convey my best wishes to each one of them and commend the organizers for bringing about a program of this scale that will be intellectually enriching. As Acting Chief Justice of Madras High Court, I take pride to declare that with the able assistance of my esteemed brother and sister judges, heading the various relevant committees, the Madras High Court has already initiated steps by constituting a committee of judges for overhaul of the criminal rules of practice to bring suitable changes in the rules in consonance with the proposed new criminal laws. The committee has taken this on priority for completing the assignment. Regarding implementation of digitizing the documents and technology, all the judicial officers of the district judiciary and all the ministerial staff in the cadre of head clerk and above are provided with digital signature for electronic signing of the judicial documents. Courts of the district judiciary are equipped with the facility of video conferencing for recording evidence, remand, etc. Vulnerable witness courts of the district judiciary are also equipped with the technology of video conferencing. Rules for video conferencing have already put in place. One-day seminar on the nuances of new criminal law was held in High Court on 17/6/2024, which was attended by the Honorable Judges of the Madras High Court and judicial officers of the district judiciary. A 3-day seminar on the new criminal law for the principal district judges and chief judicial magistrates of the district judiciary has been organized to take place in the Tamil Nadu State Judicial Academy from the 26th to 28th of this month. I wish the Conference on India's Progressive Path and the Admiration of Criminal Justice on the eve of launching the 3 new criminal laws a grand success. Quoting the word of Stephen Hawking, intelligence is the ability to adapt to change. Thank you all.
Thank you, sir, for truly delighting and inspiring us with your words today. And now, ladies and gentlemen, please join me in welcoming Dr. L. Murugan, Honorable Minister of Information and Broadcasting and Parliamentary Affairs, Government of India, to kindly share his thoughts with us.
இந்தியாவின் வளர்ச்சி பாதையில் குற்றவியல் சட்டங்கள் என்ற இந்த கருந்தரங்கிற்கு தலைமையேற்று சிறப்பு விருந்தினராக வருகை தந்திருக்கின்ற மாண்புமிகு மத்திய அமைச்சர் மரியாதைக்குரிய திரு அர்ஜுன் ராம் மெக்வால்ஜி அவர்களே, மரியாதைக்குரிய மாண்புமிகு ஜஸ்டிஸ் திரு ஆர் மகாதேவன், சீஃப் ஜஸ்டிஸ் மெட்ராஸ் ஹைகோர்ட் அவர்களே, மாண்புமிகு ஜஸ்டிஸ் ஆலோக் அர்தே, சீஃப் ஜஸ்டிஸ் ஹைகோர்ட் ஆஃப் தெலுங்கானா அவர்களே, மாண்புமிகு ஜஸ்டிஸ் ஆசிஷ் ஜிதேந்திர தேசாய், சீஃப் ஜஸ்டிஸ் கேரளா ஹைகோர்ட் அவர்களே, டாக்டர் ராஜீவ் மணி, செக்ரட்டரி டிபார்ட்மெண்ட் ஆஃப் லீகல் அஃபேர்ஸ் மற்றும் மெட்ராஸ் ஹைகோர்ட்டிலிருந்தும் கேரளா ஹைகோர்ட்டிலிருந்தும் தெலுங்கானா ஹைகோர்ட்டிலிருந்தும் வருகை தந்திருக்கின்ற மரியாதைக்குரிய நீதி அரசர் அவர்களுக்கும், இந்த நிகழ்ச்சியில் கலந்து கொண்டிருக்கின்ற மத்திய அரசாங்கத்தினுடைய அடிஷனல் சொலிசிட்டர் ஜெனரல், மத்திய அரசாங்கத்தினுடைய அசிஸ்டன்ட் சொலிசிட்டர் ஜெனரல் மற்றும் வந்திருக்கின்ற ஜுடிஷியல் ஆஃபீஸர்ஸ், போலீஸ் ஆஃபீஸர்ஸ், அட்வொகேட்ஸ், ஸ்டூடெண்ட்ஸ், மீடியா நண்பர்கள், பிஐபி, உங்கள் அனைவருக்கும் என்னுடைய அன்பு கலந்த இணைய காலை வணக்கத்தை தெரிவித்துக் கொண்டு, மாண்புமிகு பாரத பிரதமர் திரு நரேந்திர மோடிஜி அவர்களுடைய ஆட்சி தலைமையின் கீழே ஒரு வரலாற்று சிறப்புமிக்க 3 சட்டங்களை கொண்டு வந்தார்கள். ஏன்னா இதற்கு முன்னாடி இருந்த சட்டங்கள் எல்லாம் நாம் கலோனியல் மனத்துவத்தில் வெள்ளைக்காரர்களுடைய ஆதிக்கத்தில் இருந்த சட்டங்கள். இந்த சட்டங்கள்லாம் நம்மளுடைய நாட்டிற்கு, நம்மளுடைய வளர்ச்சி பாதைக்கு நாம் எடுத்து செல்ல வேண்டும். நாம் 2047 இந்த நாடு வளர்ச்சியடைந்த பாரதமாக இருக்க வேண்டும். ப்ரோக்ரெசிவ் கண்ட்ரி, இதே மாதிரி டெவலப்டு கண்ட்ரி. இந்தியா உலகத்திற்கு வல்லரசு நாடாக, இந்தியா விஸ்வகுருவாக இருக்க வேண்டும் என்று. அதற்கு நாம் பல இன்னல்களை, தடைகளை தகர்த்து கொண்டு ஒவ்வொரு துறையாக கடந்த 10 ஆண்டுகளில் மட்டுமே கிட்டத்தட்ட 1500 சட்டங்கள், தேவையில்லாத சட்டங்களை 1500 சட்டங்களை நாம் அகற்றி விட்டிருக்கிறோம். இது இந்த நாட்டிற்கு பிரயோஜனமான சட்டங்களை, தேவையில்லாத சட்டங்களை அகற்றி பிரயோஜனப்பட அளவுக்கு நாம் கொண்டு வந்திருக்கிறோம். நான் ஒரு சின்ன உதாரணத்தை உங்களுக்கு சொல்றேன். பிரஸ் அண்ட் ரிஜிஸ்ட்ரேஷன் ஆக்ட் நீங்க கேள்விப்பட்டிருப்பீங்க. அப்போ இங்க பப்ளிகேஷன் பண்ற ஒவ்வொரு பிரஸ் பத்திரிகைக்காரங்களும் 3 காப்பி கொடுக்கணும். பிஐபியில் டெல்லிக்கு 3 காப்பி கொடுக்கணும். அதுல ஒரு காப்பி எங்க அனுப்பணும்? பக்கிங்ஹாம் பேலஸ்க்கு அனுப்பணும், ராணி எலிசபெத்துக்கு அனுப்பணும். அது போன வருஷம் வரலும் அந்த சட்டம் மாத்தாம இருக்கு. எவ்வளவு பெரிய ஒரு சுதந்திரம் அடைந்து 75 ஆண்டுகள் நாம வந்திருக்கோம். அந்த காலனித்துவம் ஆனா நம்ம அனுப்புனதில்லை, சுதந்திரத்துக்கு பிறகு அனுப்புனதில்லை. ஆனா அந்த சட்டம் இருந்தது. அதை வாங்கி அங்க பிஏபியில் ஒரு பெரிய குடவுல வச்சிருக்க வேண்டிய சூழ்நிலை இருந்தது. அதையெல்லாம் தகர்த்து எறிய வேண்டும் என்பதற்காக போன வருஷம் அந்த மாதிரி சட்டம் கொண்டு வந்தோம். அதே மாதிரி இப்போ இந்த 3 சட்டங்கள் நம்ம கொண்டு வந்திருக்கோம். பாரதிய நியாய சங்கீதா, அதாவது ஐபிசி என்று சொல்லக்கூடிய அந்த சட்டத்தில் பல மாற்றங்கள் நம்ம கொண்டு வந்திருக்கோம். ஒரு வரலாற்று சிறப்புமிக்க சட்டம். நியாயம் கிடைக்கணும், துரிதமான நியாயம் கிடைக்கணும். நம்ம பார்க்கிறோம், இங்க எல்லாருமே அட்வொகேட்ஸ் இருக்கணும். ஒவ்வொரு ஏழைகளும் நியாயம் கிடைக்காம எவ்வளவு ஆண்டுகள் அவர்கள் கஷ்டப்படுகிறத நம்ம பார்க்கிறோம். பல பேர் சட்டத்தினுடைய உதவி கிடைக்காம ஜெயில்களில் இருக்கிறத பார்க்கிறோம். இந்த சூழ்நிலைகளுக்கெல்லாம் முற்றுப்புள்ளி வைக்கணும். ஒரு நியாயமான குறைந்த கால அளவுக்குள்ள அவர்களுக்கு நியாயம் கிடைக்க வேண்டும் என்பதற்காக, உடனடியாக அவர்களுக்கு நீதி கிடைக்க வேண்டும் என்பதற்காக இந்த சட்டத்தை கொண்டு வந்திருக்கோம். நேற்றைக்கு கூட நம்ம தமிழ்நாட்டில் ஒரு சம்பவம், கிட்டத்தட்ட 50 பேருக்கு மேல இறந்திருக்கிறாங்க. ஸோ அவர்களுக்கு நியாயம் கிடைக்கணும், உடனடியாக நியாயம் கிடைக்கணும். அதுக்காக ஒரு டிராகான் சிஸ்டம் இல்லாமல் துரிதமான நியாயத்தை, சட்டத்தை வழிபடுத்துவதற்காக ஐபிசி கொண்டு வரப்பட்டிருக்கிறது. அதே போல பாரதிய நாகரிக் சுரக்ஷா சங்கீதா என்று சொல்லக்கூடிய சிஆர்பிசி, அதை மாற்றி அமைத்து இன்றைக்கு வளர்ந்திருக்கின்ற சூழ்நிலை, இன்றைக்கு இருக்கிற டெக்னாலஜி, இன்றைக்கு இருக்கிற ஒரு ஐடி யுகம், இன்றைக்கு இருக்கிற ஒரு டிஜிட்டல் மயம், இதையெல்லாம் நாம சட்டத்துக்குள்ள உள்ள கொண்டு வந்து அதை ப்ரொசீஜரலாக கொண்டு வந்து வீடியோ கான்ஃபரன்ஸில் எவிடன்ஸ் கொடுக்கலாம், அல்லது ஜெயிலிருந்து இவங்க கூட்டிகிட்டு வர்றது அதை தவிர்க்க முடியும். இது எல்லாமே இன்றைக்கு நாம் அது மாதிரி சாட்சிய பாரதிய சாட்சிய அபியம் எவிடன்ஸ் ஆக்ட், அதில் பல மாற்றங்கள் கொண்டு வந்து இன்றைய காலகட்டத்திற்கான சட்டங்களை நாம் கொண்டு வந்திருக்கிறோம். ஒரு வரலாற்று சிறப்புமிக்க சட்டங்கள். காலனித்துவ மனோநிலையிலிருந்து வெளிவந்து முதல் முறையாக ஆசாதி கா அமிர்த் மகா உற்சவம், அதாவது அமிர்த் காலில் நாம் சுதந்திரம் அடைந்து 75 ஆண்டு கொண்டாடி கொண்டிருக்கின்ற 100வது சுதந்திர தினத்தை அடியெடுத்து வைத்திருக்கிறோம். இந்த 100வது சுதந்திர தினத்தில் 2047 நம்ம நாடு வளர்ச்சியடைந்த நாடாக இருக்க வேண்டும். இப்போ வளர்ச்சியடைந்த நாடாக இருக்க வேண்டும் என்றால் நமக்குள்ள இருக்கிற அந்த இடர்பாடுகளை தகர்த்தெறிய வேண்டும். அதற்காக தான் இந்த கிரிமினல் ஜஸ்டிஸ் சிஸ்டத்தில் இந்த மிகப்பெரிய ஒரு மாற்றங்களை கொண்டு வந்திருக்கிறோம். அதில் டெக்னிக்கல் செஷனில் உங்களுக்கு செக்ஷன்ஸு அது என்னென்னது எல்லாமே டெக்னிக்கல் செஷன்ஸில் மற்ற லீகல் ஃபெட்டர்னிட்டிஸ் இங்கே எல்லாம் வந்திருக்கிறீங்க. ஜட்ஜஸ் எல்லாமே கிளாஸஸ் எடுக்க போகிறாங்க. ஐபிசி சம்மந்தமாக ஒருத்தர், சிஆர்பிசி சம்மந்தமாக ஒருத்தங்க, எவிடன்ஸ் சம்மந்தமாக ஒவ்வொருவரும் ஒவ்வொரு கிளாஸஸ் எடுக்க போகிறாங்க. ஆனால் நம்மளுடைய பிரதமருடைய ஒரே ஒரு முக்கியமானது தாமதிக்கின்ற நீதி மறுக்கப்படுகின்ற நீதிக்கு சமம். அதனால நீதி உடனடியாக கிடைக்க வேண்டும் பாதிக்கப்பட்டவர்களுக்கு. அந்த நீதி கிடைப்பதற்கு இந்த சட்டங்கள் நமக்கு மிகவும் உறுதுணையாக இந்த சட்டங்கள் இருக்கும். இந்த சட்டங்கள் மிக கூடி சீக்கிரம் விரைவில் நடைமுறைப்படுத்த இருக்கிறது. நம்முடைய சென்னை ஹைகோர்ட்டில் அதற்கான நடவடிக்கை எல்லாம் எடுத்துக்கொண்டிருக்கிறார்கள். இப்போ இது ஒரு காரணமாக இந்த பப்ளிக் அவேர்னஸ் ப்ரோக்ராம் எல்லாம் நடந்து கொண்டிருக்கிறது. ஒவ்வொரு ஊர்லேயும் ஒவ்வொரு ப்ரோக்ராம்ஸ். போன வாரம் நம்மளுடைய அமைச்சர் அவர்கள் ஹைதராபாத்தில், தெலுங்கானாவில், கல்கத்தாவில், இன்றைக்கு சென்னையில் ஒவ்வொரு பகுதியிலும் மக்கள்கிட்ட இந்த சட்டங்களை எடுத்து செல்ல வேண்டும். அதுக்கு மாணவர்கள், வழக்கறிஞர்கள் இந்த சட்டத்தை பற்றி தெரிந்து கொள்ள வேண்டும் என்பதற்காக இந்த கருத்தரங்குகள், இதுபோல இன்னும் மாவட்ட அளவில் கருத்தரங்குகள், மாவட்டத்திலிருந்து சப்கோர்ட் லெவலில் கருத்தரங்குகள், அதுக்கடுத்து ஜுடிஷியல் கோர்ட் அளவில் கருத்தரங்குகள். இந்த கருத்தரங்குகள் மூலியமாக இந்த புதிய சட்டங்களை, இந்த புதிய சட்டங்களினுடைய தேவைகள் மெயினாக நாம இன்றைய காலகட்டத்திற்கு 1800களில் இருந்த சட்டங்களை வைத்துக்கொண்டு அதில் அமெண்ட்மெண்ட் பண்ணி கொண்டு வந்துட்டோம். அதையெல்லாம் வெள்ளக்கார மனநிலை, அவர்களுடைய ஆதிக்கம், அதையெல்லாம் எடுத்துவிட்டு நாம் இந்திய மக்களினுடைய பாரத மக்களுடைய கலாச்சாரத்திற்கும் நம்மளுடைய நாட்டுக்கு தேவையான சட்டங்களை நம்முடைய பிரதமரும் நம்முடைய உள்துறை அமைச்சரும் நம்முடைய லா மினிஸ்டரும் நமக்கு கொடுத்திருக்கிறார்கள். நாம் நம்முடைய புதிய பாரதத்தை நோக்கி அடியெடுத்து வைக்கின்ற இந்த புதிய பாரதத்தில் இந்த புதிய சட்டங்களை மக்களிடத்தில் துரிதமாக நியாயம் கிடைக்க எடுத்து செல்வோம் என்று கேட்டுக்கொண்டு, இந்த அருமையான நிகழ்ச்சியில் உங்களிடத்தில் கலந்து கொண்டு உங்களிடத்தில் என்னுடைய கருத்துக்களையும் வைத்திருக்கு வாய்ப்பளித்த அனைத்து சகோதர சகோதரிகளுக்கும் என்னுடைய அன்பு கலந்த நன்றிகளையும் வாழ்த்துக்களையும் பாராட்டுகளையும் தெரிவித்துக் கொண்டு விடைபெறுகிறேன். நன்றி, வணக்கம். ஜெய்ஹிந்த், ஜெய் பாரத்.
தங்களுடைய பொன் வார்த்தைகளுக்கு மிக்க நன்றி ஐயா. Ladies and gentlemen, it is now time to listen to Shri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, Independent Charge Government of India, under whose guidance these laws were framed. Sir, we request you to please address the audience.
Today's conference on India's progressive path in administrations of criminal justice system. The name of the conference is very explanatory and elaboratory. I welcome all of you in this conference. Good morning, all of you. Good morning. Vanakkam. Yeah, thank you. For this conference on the dais, Dr. L. Murugan, Honorable Minister in Parliament Affairs, Ministry in the Parliament Affairs and Ministry in the Information and Broadcasting, Government of India. Justice R. Mahadevan, Acting Chief Justice of Madras High Court. Justice Alok Arade, Chief Justice of Telangana High Court. Justice Ashish Jitendra Desai, Chief Justice of Kerala High Court. Secretary in Ministry of Law and Justice, Dr. Rajiv Mani. And Rita Vasisth, she is the Member Secretary of Law Commission of India. Earlier, she was the Secretary in our department. Srimati Anju Rathi Rana,
Additional Secretary in Ministry of Law and Justice, Sri Tyagarajan, Vice Chancellor of PIT, all the law officers, Government of India and the State Government, judges of the different High Court, sitting judge and retired judge both, and office bearer from the Bar Association and Bar Council of India. I think some participants are from the forces, CRPF, and some paramilitary forces. Some are from the police personnel. Some are advocates, senior advocates, I can say. Some are students, I think, National Law University, and all other participants. Again, very good morning. Yes, thank you. Today, I appreciate all team members involved in organizing this event. It is a remarkable event. When I say it is remarkable, definitely it is a remarkable. It is a remarkable. Legal history. Now I will talk about the legal history. Legal history is not written accurately because it was written by the Britishers. Any change in law also brings major changes in the society, be it socially, economically, financially, even demography also changes, and the system also changes due to changes in law. Changes in law is a very important event. I am telling you. 1757 was a very important year for our country when the Battle of Plassey took place and the East India Company acquired revenue rights for a large part of Eastern India, including Bengal, Bihar, Odisha. Additionally, Northeast India was also affected in year 1757. Exactly after 100 years, our country saw landmark changes in 1857. We witnessed the first war of independence, which brought drastic changes in society. The real reason behind the freedom movement of 1857 is a law made by East India Company. What is the name of the law? The law called Doctrine of Lapse. The law called Doctrine of Lapse was implemented by the Lord Dalhousie in the late 1840s. It included preventing a Hindu ruler without a natural heir from adopting an heir and taking over the area of ruler after his death. Those who did not have children could not adopt children. It was not a justice, but law was enacted. This law was not based on the principle of fairness and equality. Subsequently, first major actions taken by the Britishers after 1857 was the enactment of Government of India Act 1858. It is also a major event, which ended the rule of British East India Company, and India came under the British Crown. And in 1858, the British planned for codification of laws to serve their interests. I am reiterating again. In 1858, the British planned for codification of laws to serve their interests. British, though that the India is a very good colony and we have to rule over it for a long time, therefore we have to make a system to punish the Indians. To punish the Indians who are protesting against British. That was the basic interest of the Britishers. when our new BNS code was being introduced in the Lok Sabha, means the lower house of the parliament, at that time, Bhartri Mehta, he is a senior member of parliament from Odisha, gave a speech in parliament and said that there was nothing called Indian Penal Code. The British did not work hard. There was a Irish Penal Code. The word Irish was removed and replaced with Indians. You can make a problem if you want. It was the you can speech of the Bhartri Mehta. Now he became the pro tem speaker. Pro tem, Rajaji pro tem. Speaker, not speaker, pro tem. You are a scholar, Rajaji, but you say true word. And you are sitting with the Tamil Maran also. So you are a scholar, both are scholar. And Bhartri Mehta told that the Indian Penal Code, the behavior of the Indian people, how is the Indian society, how are the people of India, what do the stakeholder of India think, everything was absent. This was the absent from the, only one has been added. Irish Penal Code, they become Indian Penal Code. They have not taken the stakeholder on this process. They simply changed the word Irish to Indian and imposed it on us. So what happened to the Indian Penal Code? Now exactly 1 year after that they brought the Criminal Procedure Code. The Indian Penal Code was implemented to suppress the Indians. The Indian Penal Code was implemented to suppress the Indian so that it can be ensured that a moment like 1857 does not happen again. Rajaji, okay? Yes. The core nature of the Indian Penal Code is of the master and servant. The British government has made various provisions which deprived Indians of the basic human rights of the fair trial. Criminal code was based on the concept of punishment. And I'm again quoting you. The criminal code was based on the concept of punishment. Now we are changing. The Indian Penal Code has been changed. भारतीय न्याय संहिता. अंग्रेजों को दंड देना था, इसलिए भारतीय दंड संहिता लाई. मोदी जी को न्याय देना है, इसलिए भारतीय न्याय संहिता लाई. The Criminal Procedure Code came in 1861, which prescribed that Indian judge cannot punish British. You can see the fairness, rule of law of the Britishers. Criminal Procedure Code came in 1861, which prescribed that the Indian judge cannot punish British. That was the provision in the Criminal Procedure Code. No changes were done in Evidence Act of 1872, wherein words like crown and queen is still written in it, which remind us of the colonial era. Now the time has come to make appropriate changes, and some people say, why did you do it now? What was the need to amend the criminal law without consultations? I want to inform you. All that work on the reform process started in 2019 itself. Modi government has consulted and received suggestions regarding the new laws from 18 states. You remind it. We have received the suggestions from the 18 states. 6 UTs, Chief Justice of India, 16 High Court Chief Justices, 5 Law Academy, 22 Law University, We have written all the member of parliament, but we have received the suggestion from the 142 MP. We have written all the number of legislative assemblies in the country, but we have received the suggestion from the 270 MLAs and members of the public. Police investigation, Public and Police Investigation Development Bureau, PPRD, received response from the IPS officer. Some people are telling that we have not consulted, so I am elaborating it. We have received from the IPS officer, state and central forces. They were discussed in depth for 4 years. Now you can see, a committee was formed under the chairmanship of Vice Chancellor of the National Law University, Delhi, to prepare a new law. During this process, Honorable Home Minister Shri Amit Shah ji held about 58 formal meeting, more than 100 informal meeting. You can see the level of the consultation. That is not the first time that the reform have been suggested in the India's criminal justice system. Earlier, the Law Commission of India had recommended several amendments in their various reports. Now you can see the committee. Committees like Baijbarwa Committee, Vishwanathan Committee, Malimat Committee, Madhav Menon Committee also recommended the reform. Standing Committee on Home Repair, Standing Committee on Home Affairs gave its 111th report in 2005, 128th report in 2006 and 146th report in 2010. But there was no action. Now we are taking the action. It is the right time, sir, now. In fact, work on the reform process started only in 2019. It is only Honorable Prime Minister Shri Narendra Modi ji and Home Minister Shri Amit Shah ji who actually work on the ground level to amend the law as per the need of the hour. Honorable Prime Minister Narendra Modi ji has done various path-breaking work in every field in the last 10 years. And as per my opinion, Modi ji has also acted to reform and develop ecosystem for better Indian criminal justice system. First, after 40 years, Modi government came up with a new national education policy, which is completely based on Indian education, open to whole world, and will also provide a global platform to our children. Second, the foundation of National Forensic Science University, which was laid down in Gujarat 2003, which when he was CM of the Gujarat, expanded to establish the National Forensic Science University. Third, by making changes in the criminal law, after 150 years, we have made 3 new laws. These 3 changes are seen together. There can be a comprehensive change in education, forensic science, and criminal justice system. Behavioral science can play an equal role in preventing crimes as does a strict administration and good judiciary. Understanding behavior, if integrated into primary education, can be instrumental in preventing criminal tendencies, surpassing the approach of the modus operandi. Forensic science should be used in investigations, prosecution, justice system, and now the time has come to one step further by adopting it in education. This is an important step in the direction of preventing, predictive, and protective policing. An in-depth study of the criminal mind and behavior and its strategy used in preventing crimes from happening in the coming days and averting the rise of criminals, it will be a great source to entire world. The Union government on 19th June last Wednesday, on 19th June last Wednesday, at cabinet meeting has cleared the outlay of 2,250 crore to build National Forensic Sciences University. It's a very good achievement, sir. across country, an alignment with the government's policies to overhaul the criminal justice system with 3 new laws. The government plans to create a NFSU in 28 states. The government plans to create NFSU in 28 states and all union territories provide education as many as 9,000 students. The government has not only brought reform in criminal law but also determined to implement on ground in its later and spirits. I want to tell you that the British brought penal code to punish citizens of India. Now we want to give justice to Indian citizens. So there was the Bharatiya Nyaya Sangha. This is the major thing. This government is going to make efforts to stop atrocities against women on term priority. New provisions inserted in BNS first time, unlike IPC, which primarily imposes punishment, fine. BNS includes community services. Community service is a new concept we added in the Bharatiya Nyaya Sangha. You understand, Radhaji? Community service. Yeah, very good. Unlike IPC, which primarily imposes punishment and fine, BNS means Bharatiya Nyaya Sangha includes community service as a reformative measure. This move is in line with current practices in Indian society, where community service is seen as a more reformative form of punishment and addresses the harm caused while also reintegrated offenders into society. Section 1032 of BNS is a new provision which prescribes punishment for mob lynching. Organized crime has been defined in BNS. There was no offense of organized crime or punishment for it in IPC section 111 of BNS defined organized crime. Explanation of section 111 also defined offense of economic offense, organized crime syndicate. New offenses of Terrorist Act has been inserted via section 113 of BNS. Even BNS has prescribed punishment for conspiring and attempting, commit, advocating, abetting and advising include of knowing, facilitating the commission of terrorist act. Even BNS also provides punishment for organizing camp to train terrorists or recruiting persons for committing terrorist act, for being number of organizations involved in terrorist act, for harboring and concealing a terrorist. Bharatiya Nagrik Suraksha Sangha (BNSS), by providing timeline for investigation, it aims to make a justice more speedy, accessible and responsive to the needs of the countrymen. Newly inserted provisions replace outdated terminology with the more people-friendly language, reflecting a commitment to the human approach. Some major amendment in BNSS are as under. Timeline for the procedure. The bill mandates a specific timeline for various legal procedures. Key provisions include medical practitioners examining rape victims must submit their reports to the investigating officer within the 7 days. It's a timeline. Judgment must be delivered within 30 days of the completion of the argument, extendable up to 60 days. Victims must be informed of the progress of the investigations within 90 days. These are the major changes. Sessions courts are required to frame charges within 60 days from the first hearing on such charges. Zero FIR, again very important input in new laws. In section 173, the provision of filing of zero FIR has been introduced. Now when information is received by the police that discloses the commission of an offence outside the limit of the police station, it shall be entered in the book to be kept by such officer. Adopting technology in judicial process in path-breaking amendment in BNSS. In an era dominating by digital advancement, the BNSS embraces technology to streamline judicial processes, reflecting a significant shift from the traditional method such as electronic filing and summons. Electronic filing and summons, video conferencing and digital trials, e-FIR, further the provision for lodging information through electronic communications has been added, with the enabling provision that the signature of the persons giving such information be taken within 3 days before e-FIR is taken on record. It is the major change. Bharatiya Sakshi Adhiniyam, now you can see, the below words have been deleted. The below words have been deleted from the Indian Evidence Act. First time, which were neither relevant nor useful after independence. Rather, it reminds us colonial era and British rule. These are the words already was in the Indian Evidence Act. Now we removed. What was the word? Parliament of the United Kingdom, Provincial Act, notifications by the Crown Representative, London Gazette, any dominion, colony or possession of His Majesty, Churi, Lahore has been it has been by bifurcation of the countries, it has been in the Pakistan, but it was in the our evidence. Lahore, United Kingdom of Great Britain and Ireland, Commonwealth, Her Majesty or by the Privy Council, Her Majesty's government, copies or extracts contained in the London Gazette or purporting to be printed by the Queen's printer, possession of the British Crown, Court of Justice in England, Her Majesty's Dominion, barristers. These words with these words with the Indian Evidence Code, it was relevant for the country. You tell me yes or no? No, na. So we remove. It's a good thing or not? Yes, thank you. After the introduction of 3 new criminal laws, India's criminal justice system will be the most modern system. I'm reiterating again. After the introduction of the 3 new criminal laws, India's criminal justice system will be the most modern system in the world within the next 5 years. The focus of these 3 laws is on ensuring timely justice and boosting the conviction rate to curb crime. Jai Hind. Thank you.